Order. The clerk will now proceed to read the orders of the day.
Item 1, Companies Amendment Bill, second reading.
Second Minister for Finance.
Mr. Speaker, I beg to move that the bill be now read a second time. The bill introduces two amendments to the Companies Act. The first amendment seeks to exempt ship owner liens from the requirement of registration as a charge under the Companies Act. The second amendment seeks to clarify the categories of persons bound by a compromise or scheme of arrangement when a company is in the course of being wound up. Mr. Speaker, let me now take the members through the details of the two amendments in the bill. First is ship owners' liens. Clause 2 of the bill seeks to preserve the ease of doing shipping business in Singapore. Specifically, this clause exempts ship owners' liens from the requirement of registration as a charge under Section 131 of the Companies Act. A ship owner's lien is a standard feature in ship charter parties. A charter party is a maritime contract, typically between a ship owner and a charterer or a hirer of the ship owner's vessel. The ship owner's lien in such a contract gives the ship owner the right, in the event of the charterer's default, to claim payment from monies owing to the charterer by third parties. In other words, should the charterer be unable to pay the ship owner, the lien allows the ship owner to directly recover payment of sub-hire, sub-freight, or in certain instances, bill of lading freight from a sub-charterer. The term ship owner's lien is the term of art used by the shipping community to refer to liens provided to others beyond the registered owner of the ship. These include a disponent owner, bareboat charterer, or other charterer, in addition to the registered owner. In 2017, the status of an unregistered ship owner's lien vis-à-vis a liquidator of the charterer and its interaction with Section 131 of the Companies Act was litigated in Singapore for the first time. The High Court, in Duncan Cameron Lindsay versus Diablo Fortune Inc., recognized a ship owner's lien as a charge that is required to be registered under Section 131 of the Companies Act. In March 2018, the Court of Appeal affirmed the High Court's decision. As a consequence of non-registration under Section 131, a lien in that case was not enforceable against the liquidator of the charterer, and the ship owner, who would otherwise have had the benefit of the lien, ranked together with the unsecured creditors of the charterer instead. The effect of the Diablo case gives rise to several practical difficulties for the shipping industry in connection with Section 131 of the Companies Act and ship owners' liens. First, leaving aside the long-standing industry custom and practice where ship owners do not habitually register ship owners' liens, the registration of ship owners' liens is particularly difficult from a practical perspective. This is because each ship is typically subject to a continual series of charter parties, each entered into as quickly as possible to ensure that the ship is continually gainfully employed. Often, charters are for periods as short as a few days. This means that many charter parties may have been completed before a charge can even be registered. Second, given the volume of charter parties, there would likely be significant administrative and cost particularly burdensome for the shipping industry. Furthermore, the underlying rationale of Section 131 of the Companies Act, which is to protect third parties who deal with companies by disclosing charges against a company's property, is less applicable in the shipping context, as observed by the Court of Appeal in its grounds of decision in the Diablo case. Notice may not be necessary in the shipping context, since all parties who deal with charterers are aware that such liens are standard in charter parties. Moving to the specifics of the amendment, there is precedent requirements. In Hong Kong, for example, the Hong Kong Companies Ordinance stipulates that a ship owner's lien does not amount to a charge. and consequently, shipowners' liens are excluded from the requirement of registration. We have taken a different approach. In our case, the bill, while exempting such shipowners' liens from registration requirements under Section 131 of the Companies Act, maintains the Singapore court's characterization in the Dablo case of such liens as charges. The effect of this is that the shipowners' lien retains its essential nature as a security, but without the need for registration. As a result, the shipowners' lien will take priority over other charges created subsequent to it, as well as over unsecured creditors. This is unlike Hong Kong, where the position is as follows. Clause 2 contains a saving provision that preserves, where possible, the validity of unregistered shipowners' liens existing prior to this amendment coming into force. Specifically, such unregistered shipowners' liens would generally remain valid unless the relevant company is already in winding up, or a creditor has already obtained proprietary rights or interests in the subject matter of the charge. Next, compromise and schemes of arrangement. Clause 3 of the bill seeks to clarify the categories of persons bound by a compromise or scheme of arrangement when a company is in the course of being wound up. Section 210 of the Companies Act provides the mechanism for a compromise or arrangement to rearrange the rights of the company, its creditors, or members. In 2014, the provision was amended to clarify that holders of units of shares in a company can be parties to a compromise or scheme of arrangement. However, creditors and members who were bound by a compromise or scheme of arrangement before the amendments in 2014 were inadvertently excluded from the amended provision in respect of a company which is in the course of being wound up. Thus, Clause 3 is a technical amendment to reinstate these categories of persons. Mr. Speaker, I beg to move.